This is episode 33 of EO Radio Show. This episode is the second in a series discussing insider transactions. In episode 32, I gave a general overview of the federal laws regulating the transaction of business between a nonprofit and its insiders, which includes directors, trustees, certain executives, substantial contributors, entities controlled by directors or substantial contributors, and their family members. Today, I'll take a deeper dive into conflict of interest policies and considerations relevant to deciding which insiders need to respond to the organization's annual conflict of interest diligence procedures. In a later episode, we'll look closely at compensation decisions in particular. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. In today's episode, I'm going to talk in some detail about the federal tax laws regarding insider transactions. By way of background, since the advent of 501c3 and 501c4 of the Internal Revenue Code, it has been a key feature of tax-exempt status that these types of entities may not be operated for private benefit. When talking about public charities and C4s, the problematic insider transactions are known as excess benefit transactions. In the private foundation world, the rules refer to self-dealing transactions. The rules are slightly different depending on whether the entity is a public charity, a C4 advocacy organization, or a private foundation. So let's start with the specific rules for private foundation definition of disqualified persons. Generally speaking, disqualified persons with respect to private foundations include four categories. Number one, foundation managers, a category which includes trustees, directors, officers, and other persons with similar authority. Number two, substantial contributors, whether individuals or entities. Number three, family members of the individuals. And number four, entities controlled by such persons. For these purposes, family members include the ancestors, spouses, children, grandchildren, and great-grandchildren of disqualified persons, but not siblings. Complex constructive ownership and attribution rules also apply, which are similar to the controlled entity rules that apply to public charities and advocacy organizations. Now, thinking about public charities and C4s, the definition of who is a disqualified person is slightly different. In brief, a disqualified person with respect to a public charity or an advocacy organization is someone who was at any time during the 5-year period ending on the date of the insider transaction. That person was in a position to exercise substantial influence over the affairs of the organization, or a family member of such person, or an entity in which such person or his or her family members hold 35% of the voting power. So there's a lot to unpack there. The position of substantial influence, that's a term of art there, substantial influence is determined by the magnitude of the responsibilities or powers the person holds in the organization, or a totality of facts and circumstances tending to show that a person is in a position to exert substantial influence. So going into a little more detail, any one of the following three categories of persons is automatically a disqualified person for purposes of Section 4958, which applies to the public charities and advocacy organizations. Number one, any person who was at any time during the 5-year period ending on the date of the transaction in a position to exercise substantial influence over the organization. Number two, a member of the family of an individual described in Category 1, which includes the individual's spouse, brothers and sisters, and half-siblings, ancestors, children, grandchildren, great-grandchildren, and their spouses. Category 3, a 35% controlled entity, which means a corporation, partnership, trust, or estate in which the persons described in categories 1 and 2 collectively own more than 35% of the voting power. Voting power is determined by looking at holdings of voting stock, directly or indirectly, but doesn't include voting rights held only as a fiduciary. So let's talk about the easily identified disqualified persons who have substantial influence over a public charity or advocacy organization based on stated responsibilities or powers or interests. These relatively objective rules include automatic groups of disqualified persons where the person's powers, responsibilities, or interests place them in a position to exercise substantial influence over the affairs of the organization. And there are three easy to identify groups here. These include 1, any individual serving on the governing body of the organization who's entitled to vote on any matter over which the governing body has authority. That is, directors, trustees, board of governors, or whatever other title is given to the governing board with fiduciary responsibility. This doesn't include things like advisory boards or honorary board members. It's really limited to the individuals who are actually serving on the fiduciary body. Second category, this includes chief executive officers. The person may also have the title of president, chief operating officer, or any person who, regardless of title, has the ultimate responsibility for implementing the decisions of the governing body or for supervising the management, administration, or operation of the organization. And the third automatic category is the person who is the treasurer or chief financial officer, or a person who, regardless of title, has the ultimate responsibility for managing the finances of the organization. So those are three categories that are relatively easy to identify. The sometimes more difficult group to identify are those with substantial influence based on, quote, facts and circumstances. This test, which is laid out in detail in the Treasury regs, looks at all relevant facts and circumstances tending to show that the person has such capability. The factors that are looked at include all of the following. The person founded the organization. The person is a substantial contributor to the organization. And there's a special definition here for substantial contributor. That is a person who contributed an aggregate amount of more than $5,000, if that's more than 2% of total contributions received by the organization, and taking into account only contributions received by the organization during its current taxable year and the 4 preceding years. Note that's different than the private foundation context, where a substantial contributor, once substantial, is always a substantial contributor. Okay, moving on. The next facts and circumstances category is a person who has or shares authority to control a substantial portion of the organization's capital expenditures, operating budget, or employee compensation. Category 4, a person who manages a discrete activity of the organization that represents a substantial portion of its activities, assets, income, or expenses when compared to the organization as a whole. And then the fifth facts and circumstances category is where a person owns a controlling interest in a corporation, partnership, or trust that is a disqualified person, or the person is a non-stock organization controlled directly or indirectly by one or more disqualified persons. Note, the list I talked about just now should not be used to analyze insider transactions involving supporting organizations or organizations that operate donor-advised funds. There's special rules for both of those areas. So if you're thinking about insider transactions with a supporting org or an organization that's operating in donor-advised funds, there are additional persons that need to be treated as disqualified persons. So now that we've got a general idea of who our disqualified persons are, let's talk about how to avoid excess benefit transactions and private annulment and self-dealing. The best practices I'm going to talk about right now cover all of these rules and are intended to set a framework for an organization, whether it's a public charity, private foundation, or advocacy organization that wants to adopt a conflict of interest policy and procedure and follow it in the best possible way to avoid excess benefit transactions and self-dealing transactions. All charities, whether public charity or private foundations, and all advocacy organizations should follow these procedures for every transaction with a disqualified person, which involves goods, services, or property as a best practice. So how do we go about managing this set of problems? Well, step one is to determine who the disqualified persons are with respect to your organization. This depends, of course, on whether the organization is a public charity, a C4 advocacy organization, or a private foundation, as we've just discussed, probably in too much detail for many of you. But anyway, that's step one. Determine who the disqualified persons are under the applicable law. Then consider the related parties. In a complex charitable structure where there are related private foundations, public charities, special purpose limited liability companies, and possibly even a related advocacy organization, the list of disqualified persons will need to be broad enough to make sure that all the categories are covered for all of the different types of organizations. Some organizations also include staff members who would not otherwise necessarily be included in the legal definition of disqualified persons. So that's step one. Determine who the disqualified persons are that you want to be attentive to a conflict of interest policy and procedure. Remember also that with respect to disqualified persons defined in the private foundation rules, the private foundation can engage only in certain types of transactions, with the exceptions noted for no interest loans, rent-free use of space, and some narrow exceptions. For a further discussion of the exceptions for private foundations, check out episode 32, which goes into more depth there. So anyway, we finished step one, determine the disqualified persons involved. Step two, set up policies, procedures, and practices to annually document all allowable financial transactions with disqualified persons. The annual documentation will include a survey of disqualified persons in the first place, and then second, analysis of the surveyed responses to determine whether there are any potential conflict of interest transactions that need to be addressed in order to ensure that there is not an excess benefit transaction or self-dealing. Once the surveys of the disqualified persons are collected, then the board and staff get to work on gathering adequate documentation. The adequate documentation substantiates that the organization has not engaged in an impermissible transaction. The written documentation, which should be included in minutes or in a written action by the governing body, should include all of the following elements for every financial transaction with a disqualified person. Number one, the transaction must be approved in advance by the governing body or a committee that is permitted by state law to act on its behalf. Number two, the governing body making the decision must be composed entirely of individuals who do not have a conflict of interest with respect to the specific transaction. Number three, the governing body must obtain and rely on appropriate comparability data before making its determination. And number four, the authorized body must properly document the basis for its determination concurrently with making the determination. Adequate documentation should reflect the following 7 items. The material facts and disqualified person's interest in the transaction that are known to the governing body. Second point, that it being the organization, is entering into the transaction for the benefit of the organization. Point number 3 to be included in these written materials is a representation by the governing body that it has determined that the transaction is allowable under law and is fair and reasonable to the organization. Point number 4, the material terms of the transaction and the date it was approved. Point number 5, a complete list of the members of the governing body who were present during the deliberation and who voted for and against the decision. Point number 6, the actual comparability data that was considered and a description of how that information was obtained. And point number 7, the actions taken with respect to consideration of the transaction by anyone who had a conflict of interest. So let's talk a little bit about the comparability data and the due diligence. Key to all of these conflict of interest policies is that the independent directors, trustees, or members of the relevant governing body, as the case may be, have to consider the insider transaction based on appropriate due diligence, and they have to document their efforts to demonstrate that the transaction doesn't confer an impermissible benefit on the insider. The governing body will be considered to have appropriate comparability data if, given the knowledge and expertise of its members, that body has information sufficient to determine whether the insider transaction is reasonable in its entirety, which is the measure for compensation arrangements, or for a public charity is at fair market value, that is the measure for goods, services, and real property. For example, if the transaction involves compensation of an executive, the governing body should gather and evaluate data regarding comparable salaries originally paid for like services by similar organizations. This data can be derived from independent industry surveys, documented compensation of persons holding similar positions in similar organizations in the same geographic region, expert compensation studies, or other evidence of comparability. The governing body should review and attach to its resolution or minutes where it approves the compensation a comprehensive job description of the position, a current resume of the insider's qualifications for the position, and the salary, including all benefits and perks provided, including the value of any housing, vehicles, or other benefits. It's also important to note here that for public charities and advocacy organizations, Section 4958 treats any benefit to an employee that is not included in the board deliberations as an automatic excess benefit transaction. So it's really important to make sure that the board review includes a review of all elements of compensation without forgetting any minor details, because those will be automatic excess benefit transactions. Another common insider transaction to be aware of is the provision of professional services for a fee, such as legal, accounting, investment advisory, or banking services. The comparability data for these kinds of insider compensation arrangements should reflect the fees or billing rates of other similar service providers in the region who provide similar services to similar organizations so that the fair value can be established. For public charities and advocacy organizations that contemplate entering into a lease, sale, or other transaction involving property, whether the property is real property, personal property, or even intellectual property, those organizations that are contemplating that kind of an arrangement with a disqualified person should make sure that they obtain valuation data from a qualified appraiser. Wrapping up our thoughts on best practices, don't forget that the details and the analysis of the facts and comparability data should be contained in or attached to the minutes or board resolutions and should reflect on the whole reasonable inquiry and investigation appropriate to the size of the transaction. In addition, the governing body's minutes or written resolutions should describe the organization's relationship with all the parties to the transaction, the rationale for the transaction, the effort, if any, of the organization to obtain competing offers from independent third parties, unrelated third parties, and the reason why the transaction with the insider is more favorable to the organization than any competing offers or other transactions with unrelated parties, and the reason why this insider transaction is in the best interest of the organization. This written record should be created before the later of the next meeting of the governing body or 60 days after the final action regarding the insider transaction. That catch-all rule, that safe harbor, I should have called that a safe harbor, is technically from the 4958 rules, but it's a good practice to follow whether the organization is a public charity or a private foundation. In any event, the minutes of the board meeting or the written resolutions should clearly reflect that the insider or other interested persons were not participants in any conversations among the members of the governing body about the transaction, and that those insiders are not voting on the matter. Keep in mind that in many states, California included, the written record of board deliberations may be required to be made part of the public record. If you would like more information about the types of nonprofits discussed, that is, public charity definitions, episode 5 of EO Radio Show is the Nonprofit Basics episode that describes the distinctions between public charities and private foundations. So check that out if you want to explore those rules. So that's all for this episode. Be sure to check out the show notes for links to more resources. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.